Well, welcome back. And yesterday, of course, Patricia de Lille and the DA were in court, and that matter concerned a cessation of her membership, and she won. Well, now, today, Patricia de Lille and the Democratic Alliance, they are expected back in court this morning, and this time for a review of the internal charges against de Lille, and that will continue at the Western Cape High Court as well. Yesterday, a full bench found that the processes followed to terminate her party membership were unlawful and unconstitutional. The DA has since said that it would appeal the judgment. So to discuss these latest developments further, we're now joined by analyst Lukhona Mnguni from our Durban Studios. Lukhona, good morning and welcome to Morning Live.
Good morning, Sakina, and good morning to your viewers.
And so the boxing match continues, the rumble down in Cape Town. But your reaction to yesterday's judgment?
I think the judgment was expected in one way or the other. The DA seems to have been floundering a great deal in terms of how to approach the de Lille matter. They were literally scraping through whichever ammunition they could collect. They were just throwing at de Lille. It's almost like trying to find a rat in a house, and the rat keeps showing up and disappearing here and there. And de Lille is really showing up and disappearing on the DA, and the DA doesn't know whether to spin around looking for her or just self-destruct in the process of doing that. So I think, in terms of due process, in terms of laws of natural justice, affording her an opportunity to be heard, affording her a fair opportunity to represent herself. If you remember, Sakina, when they took the decision on cessation of her membership, they were just about to apply their minds to her representations as to why she should not be removed after the motion of no confidence by the DA caucus in the city of Cape Town. So this is what I mean when I say they've been scraping every sort of ammunition they can get against her. Of course, it becomes quite a witch hunt in a way when politicians go after another in that manner. And I think beyond just the judgment yesterday, there's probably an interesting background story to this whole de Lille manner, the manner in which she has been pursued relentlessly. At the earliest possible time, the DA wants her out of a position as mayor of Cape Town. And one has to wonder what is actually the motive that is driving all of this. And I suppose that might cue us into today's court proceedings.
And of course, that remains a subject of speculation for the time being. But just looking at the substantive issues, there was, of course, the case yesterday that was determined. And as you indicated, the DA were on the verge of actually hearing this disciplinary charge against de Lille, but then they opted for cessation. And that didn't quite make sense. But should we really be reading more into it than exactly what is playing out?
Well, I think we might want to read into it because it is quite disappointing. The DA over the last I would say 10 years has presented itself as a party that follows due process, as a party that respects constitutionalism. I've actually called them a technicist party that literally relies on the letter and spirit of the law to pursue its politics rather than relying on outright politicking, so being present on the ground, mobilizing every day. So they've picked up a number of constitutional matters insofar as government action is concerned, especially presidency's action over the last 8, 9, 10 years is concerned, to try and center it as part of their politics and political agenda. So they've come across as these constitutionalists, and as a result of that, everyone is expecting that even when it comes to internal party processes, they would center their process in terms of their own constitution. Of course, one of the important aspects of that judgment yesterday was the fact that even the manner in which their federal legal commission is constituted does not pass party constitutional process and muster. And that is very important because it appeared that the DA presented in front of the court what the judge Lehrange was reading as a strained and confused argument insofar as how they are interpreting their own constitution, Sakina. And it might be that they were interpreting it that way in front of the court for purposes of political expediency. Now we're starting to see a DA that is is playing politics, departing from the constitution, departing from due process and the internal rule of law, and of course not affording one of their own an opportunity to be heard properly. We can discuss the substantive, Sakina, but if they are in the wrong forum, they remain speculation. If you are saying there has to be a disciplinary action against someone, that's what we always call particulars of claim. And we say, okay, why are you making this claim? What is the supporting evidence? And the Steenhuisen report, for example, is one of the reports that have been tabled. But we probably ought to even ask, how did that Steenhuisen report come about? Because here is Steenhuisen, a parliamentarian, leading a process in a council, and seems to have had access even to state employees who are council administrators and all these other works. And does he have the local standi to conduct an investigation of that gravitas? So these are things that would be ventilated in a properly constituted forum. But as we sit today, even that Federal Legal Commission of the DA probably needs to go back to the drawing board and be reconstituted to begin with.
So the process in court today is specifically about the Steenhuisen report, and the DA stating even right now on their website that they believe that Patricia de Lille's challenge is legally flawed, basically.
Well, they believed that her challenge of the cessation clause was legally flawed. What I find interesting is that the big wigs of the DA are actually missing in this entire discussion. Whenever the DA used to go to court and they were quite convinced about their case, you'd see the likes of James Self and the likes of Musima Imane quite at the forefront of explaining what is going on. Much of the discussion now has been left to Natasha Mazzoni as the spokesperson of the party, but it actually sends a message that it might be that within the party they are no longer too sure whether this is the route that they ought to pursue. I mean, if the DA is convinced that it has compelling evidence against Patricia de Lille and that she has committed all these transgressions and they can win it at a disciplinary committee, I see no harm in the party saying, you know what, let us take this matter out of the courts, let's stop politicizing the courts, let us take it to a well-constituted Federal Legal Commission or a disciplinary committee, and let us have the matter going. Because one thing that Patricia de Lille has not come across as is to say, look, I'm unwilling to sit before a disciplinary committee. But had she allowed her membership from the DA to be seceded in this manner, it leaves everybody else who may come after her quite vulnerable at the how low at the bar is in terms of people losing their membership in the party. So that has been an important part to pursue, that political parties, as it was made quite clear by the Constitutional Court's judgment in the secret ballot matter last year, the political parties can't take for granted public reps as just merely adhering to the whims of the political party, because once they become public representatives, they take an oath of office and they plead their allegiance to the constitution and the citizens that they serve. And I think I made this point after that judgment came out, that the opposition parties will probably suffer the most in terms of interpreting that judgment to say, how do you center public representatives and the constitution and make the wishes of political parties and their politicians come secondary? And I think it's a massive tension that is still going to play itself out in our politics as to how do political parties align their party constitutions to the constitution of the country and the spirit of governance that is to be accountable to the broader public. And the DA right now is not coming out quite credible in terms of adhering to those prescripts of our constitution and fair treatment of its public representatives.
And then speaking of procedural and substantive fairness in today's case, the DA, lest I misquote them, let me read what it says on their website. They say she wants to get her hands on all the confidential evidence given to the Steenhuisen Commission, but she's not entitled to that. Sounds a bit curious, doesn't it?
Well, I mean, if she must prepare a defense, you've got to know what the actual claim is. You can't make an overarching claim that is founded on types of evidence and not be willing to submit that evidence, because one, the veracity of the evidence need to be tested so that the report is not written on hearsay, for example, and then that is posturing itself as credible evidence. I do not think it is one to look for who are the informants. That would be, doing away with the principles of protecting whistleblowers if indeed there is wrongdoing by Patricia de Lille herself. So whistleblowers need to be protected, but the types of evidence, the actual pillars upon which these claims that the DA is making against Patricia, those need to be ventilated, those need to be brought out. If we are talking about a party that wants accountability, this is the same DA at some point that wanted President Zuma to disclose how he arrived at the decision to conduct a cabinet reshuffle. So they understand the very much importance of getting particulars as to how a decision was arrived at. So I don't think it is unfair for Patricia de Lille to say, well, one, the report must come to my defense, and secondly, I need to know exactly what that report is premised on so that I can prepare a fair and credible defense. Because once you do not afford her that opportunity, the disciplinary becomes a kangaroo court with a predetermined outcome. And that's the problem with the DA. What I call a fixation on the correctness of their action that they've embarked on, to a point that when they even talk, when you listen to their spokesperson Natasha talk, there's only one way that this matter can conclude, and that's by de Lille ceasing to be a mayor, and then after that probably her leaving membership of the DA, because in her mind she's already framed that the DA's relationship with Patricia has so broken down that she even takes a non-starter issue and brings the fact that Patricia de Lille briefed Advocate Mpofu, who is an EFF chairperson, not understanding that probably in political cases, Advocate Mpofu is one of the leading legal minds in terms of understanding that, especially after he won the Ramakatsa versus Free State Province case in the Constitutional Court. So you get a DA that is highly frantic right now, doesn't know how to behave, but has already sealed the fate of Patricia de Lille before she even walks into the disciplinary hearing. The problem with that is that it causes self-harm on the party, to the point that even if Patricia sits in front of a well-constituted disciplinary committee, its outcome, if it is that she must leave as mayor and as a member of the DA, the society might say, well, it was predetermined. That disciplinary committee ceases to contain its credibility, Sakina.
Lukhona, the one thing that is clear is that the relationship between Patricia de Lille and the DA has irretrievably broken down. Even if you just look at some of the comments that they made again yesterday, talking about day zero, and one could interpret them saying that she was to blame for, day zero, and the fact that it's now pushed back to 2019 is as a result of her no longer being the executive mayor. So what's the solution? If Mmusi Maimane, as leader of the DA, or even the Federal Council of the DA, approached Lukhona Mnguni as a political analyst and said, help us, how do we get ourselves out of this mess? What would you say to them?
Well, that would be believing that they will listen and not behave like typical politicians that never want to listen, Sakina. But I think what I would say is that they must strategically retreat on this issue. They've got an election that is coming up. Someone actually made a very interesting comment on social media and say, well, just leave this thing and force Patricia to go and campaign for the DA and make her life miserable. She should probably quit in the process if she no longer believes in the vision of the DA and that she has been tormented. Of course, now it's too late for them to try and walk away from this. I think both sides of this story. So what is probably needed for the DA is to pull this matter out of court, constitute a fair and credible disciplinary hearing, give it to a very independent person. I think now the manner it has happened is that everybody within the party is so contaminated and so self-invested in the story. Get an independent person to chair this on behalf of the party, allow Patricia de Lille to present herself, because some of the things that we say are yes or no answers, she can't answer them in the media because they would have implications for her disciplinary. So constitute that ASAP. Make sure that you have got an outcome on this thing that is backed by a fair, just process, that you can now sell to the public, because everything else that they are doing now, even the mooted possibility of another motion of no confidence in the City of Cape Town Council's caucus of the DA, is again just a action that you are over chasing, Patricia de Lille, and you are not so much reliant on ventilating and making sure that we understand as the public what these claims are. Not the highlights of the claims, but the deep and substantive issues that she's so claimed to have committed. So we need that if the DA wants to retain its form, that it is a party of fairness, it is a party of freedom, and it is a party of values, because in how they've pursued Patricia de Lille, none of these seem to be at play. So what I would tell them is that go for a disciplinary as soon as possible, be out of the courts, because every time you go to the courts, Patricia comes out as the victim and the party as an instigator, and eventually with 2019 elections around the corner, that could cause much harm to the party.
Lukhona Mnguni, thanks so much for your time this morning. Political analyst Lukhona Mnguni joining us from Durban there, and nicely laying the foundation. City of Cape Town Mayor Patricia de Lille and the Democratic Alliance back in court after that judgment yesterday that she won, where her membership was basically reinstated. Today they're going back. She wants the Steenhuisen report to be set aside or reviewed. She's taking that on review, and it remains to be seen, because the DA is saying, well, you do not have a right to access to that information contained, because we need to protect whistleblowers. So that's where it's at right now. We're going to go to a break. When we come